Once you spit in a tube, who legally owns your genetic code?
Your DNA, extracted and cataloged, becomes property of someone else. Current U2S law permits this ownership transfer with your signature.
A patient's spleen cells became a profitable pharmaceutical commodity. The Foundation, Moore v. Regents of UC, decided June 1990.
John Moore underwent routine treatment at UCLA Medical Center.
In 1976, his physician discovered something unusual in his blood. His lymphoid cells possessed extraordinary regenerative capacity.
The cells would later yield a patent worth millions.
Moore's biological material became a proprietary medical resource. Moore was never informed of the commercial potential. He left UCLA with no knowledge his cells were owned. For 9 years, Moore received regular follow-up appointments. He attended faithfully, trusting his physician's care.
Each visit, more samples were extracted from his body. His cells multiplied into thousands of vials, commercially valuable. Researchers published 23 papers using his cells without attribution.
John Moore eventually learned the truth about his own body.
He contacted his physician demanding answers about the cell usage. Moore's attorney filed suit against the Regents of UC in 1984. The case would fundamentally reshape biomedical property law nationwide. California courts became the battleground for biological ownership rights. Moore's legal team argued fundamental property and medical ethics principles. The fundamental question: do patients own excised biological material? Prior law suggested patients retained property rights in removed tissue. Moore's attorneys cited established principles of bodily autonomy and consent. The historical precedent: Henrietta Lacks's immortal cells.
In 1951, her cells were taken without consent, unlabeled.
Lacks's family received no compensation for decades of research.
Moore's case offered an opportunity to address historical inequities.
The plaintiff argued, biological material is property. Theft occurred.
Expert witnesses testified about the commercial value of cell lines.
The cell line generated hundreds of millions in pharmaceutical revenue.
Patent rights belong to the Regents, not to the cell donor.
The discovery phase revealed decades of commercial activity based on Moore's cells. Evidence showed Moore signed only routine consent forms for treatment. The form made no mention of proprietary cell line development. The notation was made in his medical file, but never shared with Moore. His cells were tracked, stored, and managed as commercial inventory.
Thousands of vials were created from his original cellular material. Commercial partners paid licensing fees to use Moore's cell line.
No portion of these commercial profits were shared with the tissue source. Moore's biological contribution was monetized, but unacknowledged.
The patent outlined potential therapeutic and diagnostic commercial uses.
Companies generating millions in annual revenue from Moore's cells.
Moore's cells were sold as a commodity to research institutions.
Interstate commerce was conducted using Moore's biological material.
Ongoing cultivation and propagation occurred for decades without his knowledge. Moore's cells remained commercially viable through sophisticated preservation methods.
The cell's unusual characteristics made them uniquely valuable for research.
His cells became foundational material for decades of medical advancement.
International researchers built careers using Moore's biological material.
Scientists documented the extraordinary utility of Moore's cells.
Hospital leadership recognized the commercial potential of patient cell lines.
Institutional profit forecasts were made using Moore's biological properties. The case reached California's highest court, Moore v. Regents of UC.
7 justices would determine the nature of biological property rights.
Every argument would be recorded into official legal proceedings.
Moore's attorneys cited established principles. Bodily autonomy is fundamental.
UC argued recognizing property rights would discourage medical research. The justices probed the fundamental definition of property itself.
One justice asked, "Where does possession end and property begin?"
English common law defined property ownership through possession and use.
Moore's counsel emphasized, the tissue was removed from his body. UC argued medical advancement required researchers' protection from property claims.
The justices recorded their thoughts as competing arguments unfolded.
UC marshaled extensive research policy arguments defending tissue ownership. The argument, if donors own tissue, they might restrict its use.
Medical institutions themselves cited research interests over donor protections.
Moore could not have known what he was consenting to. Traditional property law assumes the owner knows what they're abandoning.
Constitutional protection of bodily autonomy suggests tissue ownership claims.
States have legitimate interests in enabling scientific progress.
The justices debated the boundaries of property and biology. One justice wrote, "Would this extend to all body parts indefinitely?" The final opinion would span multiple pages of complex reasoning.
Multiple justices would dissent from the majority's property rights denial.
The decision would reshape biomedical research law fundamentally. July 9, 1990, the California Supreme Court issued its decision.
The court ruled, patients have no property rights in excised tissue.
Moore lost his case in California's highest court decision.
The majority held, once removed, tissue loses property character.
Recognizing property rights would hinder research efforts, the court found.
The dissent emphasized, tissue comes from one's own body.
Without property rights, donors remain vulnerable to exploitation.
Moore would not accept the state court's decision without appeal.
Federal constitutional claims were developed for continued litigation.
The nation's highest court considered whether to hear Moore's case.
The justices voted on whether this case merited national review. The Supreme Court declined to review the decision, leaving it final.
Moore exhausted all available legal remedies, but lost comprehensively.
For 30 years, Moore established the legal framework for tissue ownership.
Moore's cells enabled countless medical discoveries without donor compensation. Companies continued generating substantial revenue from Moore's biological material.
Moore lived with the knowledge his body was commercialized without consent.
Modern consent forms became even more comprehensive in commercial license grants. Companies built billion-dollar databases from hundreds of millions of donors.
Fine print grants perpetual commercial license to genetic material.
Billions of users grant genetic rights without understanding the terms.
The decision enables modern exploitation of genetic information at scale.
The decision enables modern exploitation of genetic information at scale.
Lawmakers have introduced bills to restore genetic property rights protections.
The legal loophole became a foundation for biotech industry expansion.
Moore's decision enabled creation of worldwide genetic databases.
Millions use genomic services without knowing their DNA is commercially licensed.
Researchers access genetic material harvested from Moore's precedent-established domain.
As you can see, our aggregated genetic databases are not just data, they are critical intellectual property.
The family received nothing while Moore's cells generated billions in revenue.
Current law predates the genomic era, but still constrains protections.
New laws attempt to reverse Moore's property rights denial for modern contexts.
Without legal change, who truly owns your DNA after you spit in that tube?
Your DNA, legally owned by others, preserved in perpetuity for commercial use.